A very good evening and a warm welcome to this lecture meeting on the ramifications of the Tiger Global judgment of the Supreme Court, which has been curated together at very short notice but has received an overwhelming response. The speakers and panelists for today, Advocate R.S. Sayal, Advocate Rajesh Simran, our past president of the BCAS, C.A. Rajan Vora, and the other panelists, C.A. Mahesh Naik, Chairman of the International Tax Committee, Chetan Shah, Co-Chairman Rutvik Sanghvi, and my fellow Secretary, Office Bearer colleague Mandar Talang, and C.A. Jagat Mehta, friends. See, this I'm not in the though I am not much of a tax person, I think this judgment has definitely elicited a lot of headlines in the newspapers, and I'm sure today's discussion will clarify a lot of things. To me personally, whatever limited knowledge I have, I can only resonate two things. That this judgment really establishes the theme of substance over form. That is the first thing, which is something which I as an accounting and auditing professional also practice. And the second thing is that maybe the Mauritius route, which was very popular, people will start re-looking at that. And the third thing that I can look at is that there will be a lot of financial implications as a result of this judgment. Now, before I go and hand over, I would like to just briefly mention about the Bombay Chartered Accountants Society. Bombay Chartered Accountants Society is India's largest and oldest voluntary body of chartered accountants in existence for 77 years. It rests primarily on three pillars. One is the knowledge and education initiatives which are there. We undertake almost more than 5 lakh training man hours in every academic year. The second pillar is the publications, both technical, non-technical, as also our flagship publication, the Bombay Chartered Accountants Society Journal, which is not only referred to by the chartered accountants, but also by other professionals and even senior government officials also. The third part is on the advocacy and the representations, which we regularly make, undertake think tank and research initiatives and other related matters. We also do some social initiatives through our BCAS Foundation. Our society has approximately 12,500 members across nearly 400 towns and cities, and I'm happy to state that more than 50% of our membership is now outside of Bombay. So we are truly now an all India society spread across India, or what I refer to as Bharat. And these type of programs, especially in the hybrid mode, really give an opportunity to practitioners and fellow professionals across the country to reap the benefits. So without much ado, I would like to now hand over the proceedings to the chairman of the International Tax Committee, C.A. Chetan Shah. Thank you very much, and all my best wishes for the success of this event.
Thank you, President. Good evening, everyone. At the outset, the International Taxation Committee of the BCAS expresses its sincere gratitude to our distinguished panelists, C.A. Rajan Vora, Advocate Rajesh Simhan, the chairman of today's session, Advocate R.S. Sayal, who is a former Vice President of the Honorable ITAT, and is also a chartered accountant, and our moderator, C.A. Mahesh Naik, for agreeing to deliberate on this extremely important Supreme Court judgment, the Tiger Global judgment, on such a short notice. Thank you, sir. Thank you very much for agreeing to do that. As the President rightly put it, that this decision has far-reaching implications and has quietly, candidly unsettled what many of us believe to be a fairly settled position. A few years ago, a senior tax professional famously remarked, "In tax, certainty is a luxury, and what we really practice is informed optimism." Post this ruling, I suspect many of us are even re-evaluating even that optimism. But that is precisely why conversations like today's are so critical. We are extremely fortunate to have an eminent panel to guide us through the nuances and implications of this decision. I invite our panelists to share their thoughts. I look forward to a robust and intellectually stimulating discussion. Before I request them to kickstart the discussion, I request Rutvik to please introduce the panel. Thank you so much.
Thank you, Chetan Bhai. And as correctly pointed out by you, it has been a whirlwind since the decision has been announced, and we could not have had a better panel at such a short notice. All of them agreed and confirmed immediately. I would like to do the honors first by introducing the chairman of the panel, Shri R.S. Sayal. Sayal sir is a senior tax consultant today specializing in the field of income tax. He has been a rank holder in CA and has practiced as a CA for over 13 years before he started his stint with the Income Tax Appellate Tribunal. He has spent he has been a vice president of he's today a former vice president of the Institute of the Appellate Tribunal, and more importantly had more than 800 reported decisions to his credit. He has also authored 18 special bench decisions and has contributed in various manners to the functioning of the Income Tax Appellate Tribunal by various committee formations and otherwise given a lot of insights to the government also. He is currently practicing as a tax consultant in Mumbai and is advising major Indian corporates, multinational corporations, major accounting firms in India for the tax advisory and tax litigation at all levels of Indian judiciary. Many thanks, Sayal sir, for chairing this particular panel. Coming to our next panelist is Mr. Rajesh Simon. He is partner with Anagram Partners, and Rajesh has around 2 decades of experience in advising clients on tax structuring and navigating tax controversies, both in transactional and international tax matters. His advice extends to tax and regulatory matters relating to business transaction and business models with a focus on cross-border issues. Prior to Anagram Partners, Rajesh headed the tax practice at a leading law firm in the country, and Rajesh has been recognized for his work in tax across several global directories, including Chambers and Partners, Financial Times, RSG, and Asia Law. That being said, he has been very generous with sharing with us his insights as he has been very close to this whole decision. So we look forward to his comments. A very hearty welcome to you, Rajesh. Yeah. Coming to Rajan sir, as he already told us when we wanted to get his profile, he declined, saying that though there is only a two-liner profile to be given. He has been a past president of the Bombay Chartered Accountants Society, as the president also mentioned. More importantly, he has remained actively contributing to the society's efforts. This event is just one small effort towards that. Immediately on calling him, he told me that no, Ritvik, we will definitely do this. And not only that, he supported and guided on how this whole panel has to be structured. Many thanks, Rajan sir, for agreeing to come at this such short notice and guiding us. Lastly, we have CA Mahesh Nayak with us. Mahesh has been is a chartered accountant having more than 12 years of experience in the field of international tax, business restructuring, domestic tax, transfer pricing, and FEMA. He is currently a partner at CNK and Associates LLP. He has successfully completed the advanced LLM in international tax from the International Tax Center Leiden, Netherlands. And he is also a member of the managing committee of the Bombay Chartered Accountants Society. And as a convener of our International Tax Committee, he is one of the pillars of the committee. Many thanks, Mahesh, for agreeing to moderate this session. And he has also been instrumental in drafting the particular posers that we will all be discussing today. So many thanks to all the panelists and moderator for agreeing at such short notice. I hand over the proceedings of this panel to the chairman, Advocate R.S. Sayal sir. Sayal sir, I hand over to you, sir.
Good evening, everyone. Today's topic is the judgment of the Honorable Supreme Court in Tiger Global, having very larger ramifications. In fact, it is a path-breaking judgment, deviation from the law which appears to have been settled has undergone a change by virtue of this judgment. Very briefly, the facts are that there was a Mauritian entity holding shares in Singapore entity, and the shares of Singapore entity were deriving value from shares of Indian company. When this Mauritian entity wanted to sell these shares to some Luxembourg entity, the question arose about the deduction of tax at source. Precisely, the issue was whether the there is any liability to deduct tax at source, or in other words, whether there is a liability at all, whether the amount will be chargeable to tax in the hands of the Mauritian entity. The stand of the assessee was that since he is holding this assessee is holding tax residency certificate and is fulfilling all the requisite conditions of the double taxation avoidance agreement between India and Mauritius, particularly Article 13, so it is not liable to tax. In other words, if we look at the scenario, the item is otherwise chargeable to tax in terms of Section 911. But the entire emphasis was only about the non-taxability in terms of the DTAA. Matter went to, earlier it was for TDS 197, then matter went to AR, then went to High Court, and then finally to the Supreme Court. The Supreme Court has said, basically what they are saying is that the holding of tax residency certificate is in itself not conclusive of your residential status in Mauritius. So what is required to be seen is the management and control should be there in Mauritius. In other words, head and brain should be there in Mauritius to be eligible for this to be called as a tax resident of that state. Simply holding TRC is not enough. This was the one finding. And then secondly, they said that what was earlier considered and decided by various courts, including the Honorable Supreme Court, based on certain circulars, that is no more relevant in view of the fact that now there is introduction of GAR, General Anti-Avoidance Rules. And if GAR is actually overrides not only that, but also the treaty. And since GAR is attracted in this case, so it will override the treaty and amount will be chargeable to tax. This is the crux of the matter in which we all will be discussing right now. Yes, Mr. Naik.
Yeah, thank you, Sahil sir. Just let me try sharing the screen. Just 1 second. Yes, thank you, Sahil sir. So friends, I think over the next 10 minutes or so, so Sahil sir has explained what the crux of the issue or what the crux of the entire proceedings before the Supreme Court was. Over the next 10 to 15 minutes or so, we will go briefly through some of the facts, what was there, what the AAR held, what were the facts, what did the AAR hold, what did the Delhi High Court say, and what was Supreme Court's observations, and what was the ruling of the Supreme Court. And then we will move on to the panel discussion, so that we all have context and get the facts also in place. So the fact is, there were three entities: Tiger Global International 2, 3, and 4 holdings. They are investment companies incorporated in Mauritius. They held Category 1 global business license, so GBL license in Mauritius. They had tax residency certificate from the tax authorities in Mauritius. Now these entities had investors, not directly but indirectly, from 500 investors from 30 different jurisdictions. The assessee, so we call them as assessees because the three entities are part of the same group. They had invested in Flipkart Singapore from 2011 to 2015. Different number of shares held by each entity, and then as a part of the Walmart transaction, where the shareholders of Flipkart exited and sold their stake to Walmart. As a part of that transaction, these entities, so Tiger Global had to sell their stake in Flipkart Singapore to FIT Holdings SARL, which is a Luxembourg entity. So it was a structure where the the Mauritian entities were holding Flipkart Singapore. Flipkart Singapore had assets deriving substantial value from India. And therefore, under Section 911, there was an indirect transfer that was applicable. Yeah. So if we just look at the structure that is there, so you had, and this is just a simplified structure, it is much more complicated a structure that is there, but I think very important to look at the structure. You had a Cayman Island entity, which is Tiger Global Investment Partners, where there were investors which were coming in. So this was the pooling vehicle in where the investors came in. Then the Cayman entity held Tiger Global Holdings, which was a Mauritian entity, and Tiger Global Holdings in turn held Tiger Global International Holdings, which was Tiger Global International 2, 3, 4 that we're talking about, so which is the assessee. And these entities then further invested in the shares of Flipkart, which was a Singapore entity and which derived its value substantially from India. Another important, so the transaction that we're talking about is Tiger Global International Holdings. So in your screen, you'll see the entity in blue, which has sold its stake in Flipkart Private Limited Singapore to a Luxembourg entity as a part of the Walmart transaction. Now, another important aspect is there is a Tiger Global Management LLC entity in the US, which was the investment management managing firm, which provided investment advisory services to the Tiger Global Group. Now, as a part of the transaction, the Tiger Global entities applied for a nil withholding tax under Section 197 to the tax authorities. That was denied, and there was an order that was passed where the department gave a withholding tax rate of varying nature, so 6.05 to 8.47 to each entity. Thereafter, in 2019, advance ruling application was made before the AAR. Now, the question before the AAR was that the transaction is taxable under the Act, but the transaction should be exempt under Article 13 of the India-Mauritius DTAA. Now, what did the AAR look at? What are the observations by the AAR? The observations by the AAR were that the companies were set up in Mauritius merely for making investment in India and the other markets. So these were investment entities. The companies were held by Tiger Global Management LLC, which is a US-based investment company that invests in global markets through the web of entities located in low tax jurisdiction. Another observation by the AAR was that one of the general partners of the Mauritius holding companies is controlled by a person called Mr. Charles Coleman. And this Mr. Charles Coleman also owned and controlled the investment manager, which was Tiger Global Management LLC. And Mr. Charles Coleman was based in the US. Further, on looking at the directors, there was a non-resident director based in the US, Mr. Stephen Boyd, who was also taking, playing a key role, but there were other members of the board who were mere puppets and they were effectively not really independent. Another critical observation by the AAR, and when it came to its ruling, another critical observation was that the authority to operate the bank account up to a certain limit was there with the directors, but beyond that, in excess of 250,000 was with Mr. Charles Coleman. Similarly, in the GBL license, GBL1 license that was given to Tiger Global in Mauritius, the beneficial owner was stated as Mr. Charles Coleman. Now, on that basis, so let us understand that for what was the question before AAR was that the Tiger Global was saying that we are exempt under the tax treaty of Mauritius and therefore kindly give us an advance ruling that we are exempt. Under section 245R, in respect of the procedure before the AAR, the 245R2 provides that the authority shall not allow the application for the advance ruling where the question raised in the application, and subclause 3 states, relates to a transaction or issue which is designed prima facie for the avoidance of income tax. So, therefore, if there is a transaction which is designed prima facie for the avoidance of income tax, the AAR shall not allow the application and shall not rule on the merits of the case. Now, on the basis of the facts that we were looking at earlier, the AAR said that the head and brain of this Mauritius entities was Mr. Charles Coleman, who had the control and management of the entities. And the real objective of this entire structure was to obtain the India-Mauritius DTAA benefit, and therefore the transaction was held that it is designed prima facie for the avoidance of income tax, and therefore the AAR rejected the application it did not rule more on the merits, but it rejected the application and so that was it. Before the Delhi High Court, uh, a writ petition was filed by the assessees. Now, in 2024, the Delhi High Court, the question before the Delhi High Court was whether the AR was correct in rejecting the application, stating that there was a prima facie, it was a case of a prima facie avoidance of tax. Now, the Delhi High Court looked at what the AR ruling, what AR factual conclusions were, and said that they were materially flawed. It was not supported by actually any material on record that the decision, etc., was actually undertaken by in the US. Actually, the Tiger Management Global Management LLC, which is the investment manager, did not even have any holding in the entities directly or indirectly, and therefore, and this was a case of not Mr. Charles Coleman holding the shares, but it was directly or indirectly through various structures. But it was a case of where there were 500 investors from 30 different jurisdictions, and the assessees were legitimate Mauritian pooling vehicles with GBL1 licenses, and there was real economic substance, and there was independent board decision making power that was granted to the board. And therefore, the High Court also emphasized that treaty abuse can only be addressed through an LOB clause, and that transactions prior to 1st April 2017 were grandfathered under the India-Mauritius DTAA and therefore exempt, and that TRC was sufficient to claim the benefit of the tax treaty. So it upheld the supremacy of the TRC, the Delhi High Court, in its decision in 2024. On this, there was a SLP that was filed by the department before the Supreme Court. Now, the question before the Supreme Court was, and again, there were arguments made on the taxability, etc. The question before the Supreme Court said what we are going to answer is whether the AR was right in rejecting this advance ruling on the grounds of maintainability by treating the transaction to be a prima facie an arrangement for the avoidance of tax. Now, what did the Supreme Court held? The Supreme Court held, and again, what Sayal sir pointed out, that TRC is only an eligibility condition. It is not a conclusive proof to claim the treaty benefit. Possession of a TRC does not bar inquiry into substance, control, or management, especially in situations where there is an allegation of treaty abuse or tax avoidance. Then the other argument also was on the CBRT Circular 789 dated 13th April 2000, and that is before in front of you. So the CBRT Circular 789 of 2000, again, which is still not yet withdrawn by the department, what it holds is, in the case of Mauritius, that if you have a tax residency certificate, because the circular holds that FII and other investment funds which are operating from Mauritius are invariably incorporated in that country, and therefore they are liable to tax under Mauritius tax law, and therefore they should be considered as residents of Mauritius in accordance with the tax treaty. Because Article 4 of a tax treaty says a person resident of a contracting state is a person who is liable to tax under the domestic law of that respective contracting state. And therefore, if it's an entity that is incorporated in that country, in Mauritius, they are liable to tax. And therefore, it held, in para 2, it first talked about the dividend, and it said that wherever a certificate of residence is issued by Mauritian tax authorities, such TRC will constitute sufficient evidence for accepting the status of residence as well as beneficial ownership for applying the tax treaty. And in third para, which is not related to dividend, it said that this test of residency mentioned above would also apply in respect of income from capital gain on sale of shares. And accordingly, FIIs, etc., which are resident in Mauritius, would not be liable to tax on income from capital gains arising in India on sale of shares as per para 4 of Article 13. This is under the old treaty, of course. But so therefore, Circular 789 basically said that if you have a tax residency certificate and you are incorporated in Mauritius and that TRC from Mauritius, that is sufficient for TRC as well as beneficial ownership, and you don't need to look into that. Now, what did the Supreme Court hold? The Supreme Court said that this CBDT circular, which states that TRC is sufficient for a resident of Mauritius to claim the treaty benefit, is no longer applicable because there's a change in the legal environment today. When this CBDT circular 789 was passed, and again CBDT circular 789 has been upheld by the Supreme Court in Azadi Bachao Andolon 2003. And at that time when the decision was passed, the legal environment was different. Pursuant to that decision, pursuant to even Vodafone, there is a change in the law, there is a change in the policy. Today, there is a general anti-avoidance rule that has been introduced. And the tax treaty with Mauritius has also been amended. Similarly, even the government position is clear with indirect transfer provisions being brought into the act by, of course, that is under the act itself, not in the treaty, but that being brought into the act. And therefore, the legal environment for this CBDT circular has changed, and the decision of the Azadi Bachao Andolan, there is a difference, and therefore that has to be now given a go by, and therefore it held that CBDT circular 789 will not apply. Now, some interesting observations and some things which could have other challenges also. It held that indirect transfer of shares does not automatically qualify for protection under Article 13 of the India-Mauritius DTAA. What is covered is only a direct investment and direct transfer of Indian company shares is covered under Article 13 of the India-Mauritius DTAA. And again, the other point was there is a grandfathering that is applicable under the India-Mauritius Treaty, but it only applies to sale of transfer of shares of transfer of shares of a Mauritius company, sorry, not of an Indian company, and not that of a Singapore company by a resident of Mauritius. In this particular case, it is not a transfer of shares of an Indian company, but it is transfer of shares of a Singapore company by Tiger Global, and therefore the grandfathering provisions will not apply under the treaty. Again, on the basis of the facts, it held that the head and brain of these entities was not in Mauritius, and therefore it held that GAR provisions would apply even to cases where investments were made prior to GAR coming into force. So you also have the GAR provisions that are there. And let us look at one important aspect of GAR. You have Rule 10U. Rule 10U says that the provisions of Chapter 10A shall not apply, that is GAR, shall not apply to any income accruing or arising or deemed to accrue or arise to or received or deemed to be received by any person from transfer of investments made before 1st of April 2017 by such person. So if you read Rule 10U1D, it states that any income that is arising from a transfer of an investment which was made prior to 1st April 17 shall effectively be grandfathered and GAR provisions shall not apply. There is a Rule 10U2 which says, without prejudice to the provisions of Clause D of Subrule 1, the provisions of Chapter 10A shall apply to any arrangement, irrespective of the date on which it has been entered into, in respect of the tax benefit obtained from this arrangement on or after 1st April 17. So what 10U2 says, that if there is an arrangement, then irrespective of the date on which it has been entered into, then the provisions of Chapter 10A, that is GAR provisions, can apply. And therefore, the Supreme Court held that Rule 10U1D only applies for investments and not to arrangements on account of Rule 10U2. And therefore, in this particular situation, it is an arrangement, and therefore it can, therefore the GAR provisions may not apply. And again, we'll come to, we'll get the views of the panelists and what is the difference between investment and arrangement, later on. And subsequently, it also held that even if GAR provisions don't apply, there is a court held anti-avoidance provisions or law, sort of soft law, which is the judicial anti-avoidance rule or JAR. Those can also apply in this case. And even if one applies JAR, the head and brain of the entities is not in Mauritius, and therefore the benefit of the treaty cannot be given. This was the ruling of the Supreme Court. Now, with the permission of the chair, I would like, if we can, we can start the panel discussion where we can ask the panelists the questions.
Yes, please.
Thank you. So first question to Rajan Bhai. So the question before the Supreme Court was whether the AR was correct in stating that there was a prima facie avoidance of tax issue. Now, however, in the Supreme Court conclusion, they have also sort of concluded that capital gains after 1st April 2017 are taxable in India under the Act read with DTAA. So, how does one really reconcile this finding with the question before the Supreme Court? Is this the final ruling, or would some Tiger Global need to undergo entire scrutiny proceeding, which we know that is there, or in those proceedings, is this ruling again? And if there are those proceedings, is it only a prima facie? Is this only a prima facie ruling, or is it sort of binding on the authorities in terms of taxability?
Thank you, Sal sir. Thank you, Mahesh, and thank you, organizers, for giving us opportunity and making us read the full decision. How far we understood, we'll come to know a little later, but at least opportunity for us to study the decision. I'm really grateful to the organizers for at least giving opportunity to ask us questions, so that at least we'll be able to understand what is really the decision is. Because as we understand, first 102 pages is an excellent summary of entire proceedings, the way Mauritius Treaty, investments, everything has been come through. But when we start after 102 fair, where the discussion and summary, the finding starts, there we start getting confused as to what is the finding, which is as rightly Mahesh asked the question, at what is the finding? Is it saying that this is all transaction is void, therefore nothing is possible? Or it is only a saying that AR was right and Delhi High Court wrong? So I think that's a full 360 degree we are taking a turn. Just to step back, as we are aware, Azadi Bachao was filed after the circular which was issued by 769 circular was issued by the government. That was challenged as a public interest litigation. And Delhi High Court decided in favor that the government cannot issue such circular, giving blanket immunity to all the transactions before 1417. So that was challenged then there. Against which department went to the Supreme Court and they argued, no, we have power to do this based on our economic conditions, based on our economic needs, developments. That is what is required by us. So therefore, we are justified in issuing such circular. And Supreme Court upheld that circular with reversing the Delhi High Court decision, and very detailed order has been passed. Followed by that was a Vodafone, again, very complex structure. I would not say as complex as anything else, but it was a very, very complex structure. After studying that complex structure also, and for various other reasons, Supreme Court said the treaty benefit has to be granted based on circular. And there could be several reasons for entering in the treaty. And once we agree to certain commitments, then you cannot go back, because this is a mutually what is agreed between two countries cannot be superseded by subsequent legislation. But that was a clear finding given by and which we find that it has been also been reiterated in engineering analysis in the subsequent judgment. And they have clearly said, subsequent amendment in the domestic rules, domestic law cannot supersede or amend the treaty. So this was so far so good. Now, when it came before the AR, the issue which was whether it is entitled to, according to me, AR had gone much in detail, though full order is not publicly available, but at least what we could get from the Supreme Court, High Court decision and Supreme Court decision is, they went in quite in detail, examined everything to find out whether there is a modus operandi to avoid tax. So on that basis, they proceeded further and came to the conclusion this is a scheme for prima facie scheme for avoidance of tax. Therefore, we are rejecting the application. What does it mean? Once the AR application is rejected, the matter goes back to the officer, and officer is free to deal with this matter in the normal assessment procedure. So he will get full opportunity to examine further, even though a lot of material has been collected by AR, but still AO will get full opportunity. Against which, as we very aptly summarized, matter went to the High Court. High Court said, no, looking to the facts of the case, looking to the precedences which are already there, so many precedences, so many AR rulings, this is a valid structure, what we call it SPV structure, which is used for the purpose of investment via in Singapore or Singapore to India. That does not make a difference, but there is a structure created. And all the necessary tests which are laid down in all other earlier decisions will be also satisfied. So there was no reason for AR to reject it as a prima facie case of avoidance. After that was happened, department went to the Supreme Court. So really the issue before Supreme Court, as we can find from the question which is read in the SLP, is a page 51, para 11. They have reproduced what is the exact question. And question was only whether, limited was whether AR was right or Delhi High Court was right. So looks that decision should have been only on that basis, saying that no, AR was right and Delhi High Court was not correct. And therefore, a matter should go back to the assessing officer and normal proceedings should start. But while coming to that, they have gone into several other aspects. They have reproduced several other provisions. And as you rightly pointed out, as Sayal sir also rightly said, we really fail to understand what is the finding. And that's what, as you summarized, and which will come up in the later courses. Because if you find page 120, para 33, there is some different observation. When you come to page 122, para 36, there are some different observations. When we come to 133, first it starts with saying that no, it is a prima facie case of tax avoidance. But later 3 lines clearly says that this is a complete tax avoidance, not prima facie, it's a complete case of tax avoidance, and therefore it need to be there. So therefore, I'll just, for the benefit of everybody, I'd like to read that one paragraph, which is 5 lines, which is a conclusion paragraph. In our view, once it is factually found that unlisted equity shares on the sale on which assessee derived capital gains were transferred pursuant to an arrangement impermissible under the law, assessee are not entitled to claim exemption under Article 13(4) of the Income Tax Act. We'll come back to arrangement, what Manesh referred to, arrangement versus investment. Revenue has proved that transactions in the instant case are impermissible tax avoidance arrangement. And the evidence prima facie establishes that they do not qualify as lawful. Consequently, Chapter 10A becomes applicable. That is the GAR chapter becomes applicable. Now, GAR has never been invoked by anybody here. It was only JAR which was invoked. But they said Chapter 10A becomes applicable. Applications preferred by the assessee relate to the transaction designed prima facie for tax avoidance and were rightly rejected as being hit by threshold bar to the maintainability as to the enshrined in the provisions proviso 3 to section 245R2. So we stop here. Suppose we stop here, that means we would have gone back to the assessing officer to proceed. But they didn't stop there. The further they said, accordingly, capital gain arising from transfer effected after cutoff date, that is 1417, are taxable in India under the Income Tax Act with the applicable provisions of treaty. Judgment of Delhi High Court therefore deserves to be set aside. So there is complete U-turn when in that one paragraph itself. Once they say it is tax avoidance scheme under 245R, but they didn't stop there. Then they said further. Now what will happen, as you rightly asked the question, and Sayal sir also mentioned, matter will go back, has to go back to the assessing officer. He will start the proceeding. And if we see at the beginning of the decision, there has been clearly mentioned that the assessing officer after Delhi High Court wanted to start the proceedings immediately. And in fact, the stay was granted by Supreme Court. You don't proceed. Either on so Delhi High Court order was stayed, as well as the prohibition on the officer to proceed in the assessment. So both had happened. So now they will go back to the assessing officer. Assessing officer have to start from there. But what is the assessing officer going to do? Or GAR panel going to do? Even if they refer to the GAR panel and everything, I do not know whether they can refer at this stage. But even if they refer, already finding is given by the Supreme Court in more than clear terms in paragraphs which I have referred to, paragraph 33, 36, and paragraph 50. If it is so clear finding, what is GAR panel going to do? They will only reproduce certain paragraphs of the Supreme Court order and it will happen to be there. So therefore, at least I would say in loose terms, there was overreach by Delhi High Court while cancelling the AR ruling. To cancel that order, Supreme Court has got further overreached and said that each and every sentence, each and every finding which was given by Delhi High Court is not correct, and therefore they have also superseded everything upon that or cancelled Delhi High Court, set aside Delhi High Court. So to reply to your point in brief, according to me, when we read all the decisions, particularly para 30, 33 and 50, matter has to go back to the assessor and it has to start proceeding. But it is only a paper transaction, paper order will happen. Decision is already made. So there's nothing, if the Supreme Court of the law of the land, which is gives the law of the land, is clarified what is to be there, what is going to the GAR panel or assessing officer to do. So that's a brief answer to what you have mentioned.
I like to add something here.
Please, sir. Please.
So the point is that, first of all, the caveat is that I'm just expressing my view as I feel. Actually, I'm a nobody to really say that High Court is right or High Court is wrong or Supreme Court is. I'm nobody to say that Supreme Court is wrong or High Court is wrong, even AR is wrong. This is just a discussion amongst our professionals only. From that perspective only, what I feel, this is what I'm putting across this gathering. First of all, if we look into the question, before that, before the Supreme Court, the impugned judgment was that of the High Court, not of the AAR. Before the AAR, the SEC has accepted that 13.3A is not applicable. They only wanted benefit under Article 13.4. And the AAR said, no, prima facie, there is a tax avoidance. So when the matter went before the High Court was to decide as to whether it was a prima facie judgment of the AR right or wrong. High Court did two things. It not only reversed the AAR, but it went a step ahead. It decided on the taxability of the and non-taxability of the amount. And that too, when the matter was before the High Court, what was accepted before the AAR was claimed before the High Court. Before the High Court, again, the claim was about Article 13.3A, not Article 13.4. And based on that, means Article 13.3A, which was left before the AR, and the case was focused only on Article 13.4, that point was again raised before the High Court, and the High Court gave decision just on Article 13.3A only, by holding that the income is not chargeable to tax. So when the High Court decided not only about the correctness of the order of the AR, but also decided on the taxability or non-taxability of the amount. And it was the judgment of the High Court which was impugned before the Supreme Court. To my mind, all the issues were open before the Supreme Court. And now what we say that what will go back to AO, again when we see the judgment, of course, Supreme Court has sent the matter back to the assessing officer. They will be starting the proceeding right from the beginning itself. But if we see the judgment in the entirety, of course, there are certain ratio decidentis given in the judgment, which will apply across the board. When TRC is not conclusive, nobody can say that TRC is conclusive. This is one thing. Circular 789 has lost its validity. Nobody can say that it is still valid. These are the ratio decidentis which will be binding on all the authorities, all the courts all over the India. But the AO will examine whether this transaction falls within the ambit of GAR, and all the entire procedure will have to be gone through. So what I feel is that when the impugned order before the Supreme Court was on both the issues, not only correctness of the AR order, but also about the granting of exemption. So it had no option but to decide on both the issues. This is my point. Thank you.
Thank you. Thank you, sir. Rajesh, so in Tiger Global, if you see the Delhi High Court, when it has held in terms of the facts, etc., it has held that the facts considered by the AAR were not supported, etc. One observation was that it's an investment entity with 500 investors from 30 different jurisdictions. Now, given that, still the Supreme Court has held that the head and brain of Tiger Global was in US and not in Mauritius. So how do you reconcile these kind of two facts and the ruling with the fact that there were 500 different investors from different jurisdictions? How do you really determine where the head and brain are situated, especially when there is not, it's not like a day-to-day activity or a significant number of activities that are undertaken?
Thanks, Mahesh. I think as a general corporate matter, right, even the test that you try to determine basis ownership and the test that you determine basis control are always seen as two independent aspects. So merely because somebody owns 100% of the shares, but if control is vested with somebody, means that these are two independent tests. So the fact that there were 500 indirect shareholders, they were not direct shareholders, they were indirect shareholders in the Mauritius entity, does not necessarily go into where the control and operations of the entity actually are. And in fact, what becomes interesting, and I know that while you speak about head and brain of the company, the head and brain argument was actually the argument from the ASG. The ASG at multiple points in time has said that the head and brain is elsewhere, that is there. If you see the findings of the Supreme Court, finally, and what they have actually indicated as the correct way to apply the test, which you will find in para 48. What they have actually finally said is that the effective management and control was not in Mauritius. So the key from a court standpoint was, while we may say that head and brain, but from court standpoint, it was that your effective management and control was not really in Mauritius. So they have looked at it as a residency issue to say that have you really met the threshold that you are a resident of Mauritius by demonstrating that the effective management and control was in Mauritius. And then that's where they've gone into, at least two facts appear to have moved the needle from their perspective. One was the signatory, which was given to Mr. Charles Coleman. I think that move definitely did move the needle for them. And the second one that appears to have moved the needle seems to be the statement around beneficial ownership. But again, when I step back and say that, listen, is it control that matters or ownership that matters? I think fundamentally the court's real inclination was always towards control. So, and which is where they said that, listen, it does not appear that this Mauritius entity's control appear to be in Mauritius or vested in the directors, but somebody else appears to be the one who's taking all the actions. And therefore, on that basis, they have said that, listen, you are not meeting the threshold requirement. Now, the threshold requirement that they say that you are not meeting is not as straightforward, because they're saying that it is through use of whether judicial anti-abuse or GAR, but not really your classical test of residency, because your classical test of residency only means that whether the person is liable to tax in the state of residence. And that's a test which was anyway met. And obviously, you have a series of judgments in the past which talks about what is meant by liable to tax from a residency standpoint. So that test was already met. The Supreme Court has introduced one more new test to say that, listen, it is not just this liable to tax, but I will start looking at where the effective management and control is in order to determine whether the residency test has been met for the purposes of giving effect. Otherwise, it's a potential case for application of GAR or JAR. And Sayal sir, please.
Yes, I fully agree with you that in fact, if number of investors are from different countries, that does not mean that the management control is also in different countries. Take a simple example of mutual funds in India, where thousands of persons are contributing across the country. So does it mean that the management control is throughout the country? It's only where the centralized investment decisions are actually taken. That is the decisive question for deciding whether the management and control is at that place where the decisions are actually and formally taken. To that extent, I fully agree.
Right. Thank you. So Rajesh, I think continuing, I think Rajan Bhai referred to Azadi Bachao, and also, we had the Supreme Court in the case of Vodafone. Now, how do you really reconcile these decisions? So Tiger Global with Azadi Bachao, where, it talked about treaty shopping, Vodafone, where there's a specific, while it was not really from a treaty perspective, but there's a specific observation by the Supreme Court on TRC, if you see para 314 of the Vodafone decision. So how do you really reconcile, these, this decision with the earlier two kind of judgments that were passed?
So you have to break it down, right? What does the Supreme Court in Tiger say? The Supreme Court in Tiger says that I agree with Azadi, I agree with Vodafone. The law has changed subsequently. Therefore, some of the aspects around TRC, etc., may not be relevant. But however, what the Supreme Court in Tiger says is that, listen, both in Azadi as well as Vodafone, it was not a case where the gate was completely shut for the revenue. That they could never challenge a transaction once a TRC was produced. What Tiger says is that they're saying that even in Azadi and even in Vodafone, if there was a fraud, sham, colorable device, those are conduit structures, those are all potential situations where judicial anti-abuse can be used. And obviously there are observations in Vodafone in the later part which say that if the government wants to introduce a general anti-avoidance, it is the government's prerogative to introduce a law. And that is the part which Tiger says that, listen, Vodafone itself has said that if you introduce law relating to GAR, then that can be applied. But you're right in one aspect, because when you go back to Vodafone decision, and there are parts which cannot necessarily be reconciled, because when you look at, I know you alluded to para 314, but even if you look at para 313, which they have quoted in the judgment, which talks about the fact as to what is the circumstance when the treaty benefit can be denied, because that's the proposition which Vodafone has given as to when can treaty benefit be denied, where they have said that if it is established on facts that the Mauritius entity has been interposed as the owner of shares in India at the time of disposal of the shares to a third party solely with a view to avoid tax. Here again, it was a moment in time approach which Vodafone had said that if at the time when there is a disposal, then you introduce a Mauritius entity, then yes, you can potentially apply judicial anti-abuse rules in order to deny treaty benefits. Then they have gone into circumstances which say that it is being interposed as a device, or if it is used for round tripping and other illegal activities. So the scope which Vodafone gave was a very narrow scope. The argument which was made before the court in Tiger was a much broader scope, which sort of said that, listen, you have to look at it not form over substance, but substance over form. While the court by itself has not necessarily said that in all cases it should be substance over form, but what the court has necessarily indicated, two things, is that they appear to have broadened the scope in respect of what is meant by in some sense, the sham, conduit, device, fraud arguments, they appear to have expanded that beyond potentially what was given in Vodafone and Azadi, and which is where again it starts getting into when you start getting into their conclusions, and again in I think para 48 probably becomes the most 48, 49 and 50 are probably the most important part of the judgment, where they have very specifically said that the denial of the treaty benefit is driven by lack of commercial substance and the fact that the place of effective management appears to be somewhere else other than Mauritius. So somewhere, while they have said that yes, Vodafone and Azadi has not completely shut the door, but in interpreting both of them, and obviously they had to be consistent, but they appear to have opened the door a lot more than what Azadi or Vodafone indicated.
Yes, insofar as these two decisions in Azadi and Vodafone are concerned, it's perfectly all right that the Azadi is based on a circular. No particular provision was under consideration. And the Vodafone is based only on the provisions of the Act. No treaty was involved. But after these two decisions, much water has flown. GAR has been introduced. You look at approach which was there in Vodafone has been substituted with the look-through approach statutorily. This section 911 contains particular explanation to rule it out that look at is not required, look through is not further required. And when this section 911 has been amended and the indirect transfers which were earlier not covered under the tax net, when the Vodafone decision was there, when all the relevant facts and the law prevailing was without indirect transfer, and subsequently when the indirect transfers have been brought into picture and the court is deciding in the light of the law as it is applicable, including the indirect transfers. So obviously, we can't say that what was decided in earlier decisions can be or must be reconciled with the later decision, because what was decided in the earlier decisions was in the backdrop of a different provisions of law, and what is now being decided is in the backdrop of different provisions of law. Now you see, GAR is there, GAR is also there, and GAR has not only overriding effect over the act, but it has also overriding effect over the treaty. You see, Section 95 specifically says that notwithstanding anything contained in the act, means even if everything is correct as per the act, Section 95, Chapter 10A will apply. And it has been reiterated through Section 100, which says that the provisions of this chapter shall apply in addition to or in lieu of any other basis for determination of tax liability. Means GAR has superimposed upon the provisions, existing provisions. And insofar as the DTAAs are concerned, again Section 90 subsection 2A has been introduced, which says that the GAR will have overriding impact over the DTAA also. So when the position is that under the domestic law as well as under the DTAA, GAR has been made overriding effect. Obviously, the decision has to be based on the law which is applicable at the material time. The decisions taken at the early point of time, those may not have that significance to my mind.
Sahil sir, just to supplement the point and request you to clarify
Yes.
2 points, because we have to, what Supreme Court has gone saying that the conditions which are required in the GAR are more or less need to be satisfied, and on the basis of which they feel that there is a tax avoidance scheme of tax avoidance. But there is a mandate given or understanding or a protocol which is executed with Mauritius, specifically saying all transactions of shares purchased before 31st March 17 are grandfathered. Therefore, merely because subsequently we brought in GAR, subsequently we brought in rules, subsequently whatever changes have been made, and even in the GAR provisions or all the provisions, we have specifically said that whatever investments made prior to 1/4/17 are not to be taxed. They are grandfathered. If that is the situation, if Supreme Court was to take a different view, ignoring what is held in Vodafone, ignoring what is said in engineering analysis, which specifically says any subsequent amendment made in the act which is contrary to the treaty, unless treaty is modified, unless protocol is done, it cannot be superseded. Keeping this in mind, was it fair on two-member judge, because constitution of this was 2-judge bench, Vodafone was 3-judge bench, engineering analysis was 3-judge bench. Was it appropriate for Supreme Court? We are little, I am saying not appropriate for us to decide whether appropriate or not appropriate, but just as academic purpose, would it have been better that it would have referred, like in case of what we recently, Roka case where shell drilling matter was disputed, difference of opinion between the two, was referred to the larger bench. Same way, if they were differing from engineering analysis, if they were differing from Vodafone, was it appropriate that they should have gone to the larger bench to decide on this issue? Because what they have tried to do is apply the law as has been passed after the amendment when the investments were paid prior to 1/4/17. So just for elaboration for our understanding, sir.
So there are 2 aspects which were raised, Mr. Rajmogara. First is about whether there is any need for reference to a larger bench, given the fact when the earlier decision was there. To my mind, there is in fact no need to make a reference to the larger bench. The reason being that the earlier decisions were taken in the context of different taxing provisions. If the facts and law remains the same, and the subsequent bench feels that they are not agreeable with those facts and law, then of course they cannot go ahead with the same earlier decision. They will have to refer to a special bench, larger bench, if they want to deviate from that. But if the law has undergone change or the facts have undergone change, in that case there is no need for a larger bench. Here is the case in the facts may be almost similar, but the law has undergone change. When the law has undergone change, so to my mind, we can't say that there was a need for making a reference to the larger bench, because they have considered the earlier judgments, thoroughly considered the earlier judgments. They distinguished those judgments by telling that what was there prevalent at that time when the judgments were rendered and what is the new law. So that is the reason which really compels me to say that larger bench was not required. And your second question about the grandfathering of the investments made up to 1/4/2017. Here again, the point is that when GAR is there, what is the requirement of GAR? When a transaction becomes impermissible avoidance arrangement, IAA, Section 96 deals with that. Section 96 says when the main purpose of the transaction is to obtain tax benefit, and means there is a plus, and amongst others, that arrangement lacks commercial substance. So when these two conditions are simultaneously satisfied, if only one is satisfied, second is not satisfied. Suppose there is the purpose is to obtain tax benefit, but that is not because of lack of commercial substance, but because with the existence of commercial substance, then GAR is not applicable. It is only when both the conditions are satisfied, that one can say that this is an impermissible avoidance arrangement. And now what is the commercial substance has again been dealt with in Section 97(1). 97(1) that says when there's a round trip financing, it will amount to lacking commercial substance. In clause C, they have said when the location of asset or location of place of residence of any party is without any substantial commercial purpose other than obtaining a tax benefit, it lacks commercial substance. Means when either of the two is lacking, a transaction becomes IAA. It falls under IAA. When it falls under IAA, it is not an investment, it becomes arrangement. So that is the reason that even Rule 11U also, it has divided it entire thing into two components. One is the investment. Investment means what? Investment means where it is not IA, means where even though the main purpose is to obtain tax benefit, but that is not because of lack of commercial substance. Where the purpose may be of saving tax, but there is no lack of commercial substance, then this section IA is not invoked. Where both the conditions are simultaneously satisfied, then the transaction comes from investment to arrangement. That is the point. And once it is arrangement, it is covered under GAR. And of course, GAR overrides GTAA. When GAR overrides GTAA and the transaction is lacking commercial substance by reason of there being a circle of round-trip financing or location of parties is such so as to obtain tax benefit. So when it becomes impermissible avoidance arrangement in terms of Section 96, right with Section 97, it covers under GAR. Once it is covered under GAR, it overrides DTAA. That is the reason for having two categories. One is investment, other is arrangement. So investment means where it is not GAR, arrangement means where is GAR.
Absolutely, sir. So slightly we'll deviate from the main point. Investment made is 2011. Investment are sold in 2018. 7 years these are supposed to be a valid investments with all full support of the commercial substance, valid. Their income has been taxed in the Mauritius. Everything has been done regularly. No challenge to their TRC by any authority, neither by Indian government nor by the Mauritian government. What Vodafone says, which you rightly referred to, sir, and which Rajesh read out, what is it Vodafone says? What could be round tripping or what could be tax avoidance scheme is if somebody is inserted, Mauritius is inserted at the time of disposal of assets. That is not the situation here. Therefore, my thinking is, you may be right, sir, but my thinking is, you can't go to the GAR because GAR was not available when I made investments. And ultimately, if we see, Supreme Court has gone round and round, but ultimately they say, looking at GAR, a JAR. So ultimately, JAR is JAR, what was there before Vodafone. So if they are holding me as a not commercial substance or tax avoidance, it has to be on the jar, not on the gar. If that is the situation, that's why my point was it not fair? Because they are reviewing what is the finding given in Vodafone and using it partially in the decision to hold it against. That was my point. Rajesh, I think you were saying something.
Yeah, I think the struggle which I have been having with the judgment is I have no problem with the fact, leaving aside the way that they looked at the interpretation, that they wanted to apply GAR to the transaction. Because admittedly, that was a change in law subsequently which has happened. The interpretation of it can be contested, but I have no problem with the fact that they have said that, yes, I'm going to apply the law in respect of GAR for the transaction. Because they're at that point in time, they're not bound by Vodafone or by Azad. And they can take their own path once they say that I'm applying GAR. And which is where I do agree with Sahil sir, when he says that, look at the GAR provisions, why can't I apply it? Now we can argue around whether it should apply to grandfathered or not, but leaving that aside, the real problem with the that was actually coming in was that for anybody to apply JAR, there you're bound clearly by what the scope of what Vodafone has said and what Azadi has said. On what do you mean by the door is open? There is no problem on application of judicial anti-avoidance. Azadi had opened the door and so did Vodafone. But the question is that the door was opened within a very specific narrow framework. And that narrow framework, in some sense, in Tiger, they have deviated and opened it much more, which to my mind was never something that was contemplated either under Vodafone or under Azad. So I think that's where the trouble actually is, that if you are applying JAR, then you are bound by previous law. If you are applying GAR, you have the entire flexibility. And ultimately, in conclusion, when we see, they have essentially, in some sense, said that please, it has to go under Chapter 10A. So, which means the bigger challenge now is that even when it goes to the assessing officer, is it really, it has to go under 10A, or is it a judicial anti-avoidance provision? Because for judicial anti-avoidance, to my mind, I would tend to think that the provisions under Vodafone and Azadi, which will still continue to operate even in future, because those are general principles. And Sayal sir, please do let us know if you have a different thought.
Yes, yes. I really want to clarify first that I am not for or against any judgment, to be very frank. Means now the fact of the matter is that the judgment is there and we have to live with this judgment. If we start finding that there was something lacking in this judgment, or this ought to have been argued, this ought to have been done, that is of really only academic interest only. Now we have to see that how in legal framework something can be done. By remaining within the framework of the judgment and applying the law, can anything be done to really come out of the exceptions which may be open here and there in the judgment? That is the only thing which I want to say. I am not for or against any taxability or non-taxability, because I am also a professional like all others. And this is a discussion amongst the professionals only. So that is how we are here. And coming to the question of Mr. Vora, what you have said is, what you are saying is right. You say that the transaction was entered into 2010 or 11, and it has actually, sale has been made later on. But the point is that when GAR is applied only when tax benefit is sought to be taken. When tax benefit can be sought to be taken, or when addition can be made, when there is a possibility that you realize some gain, and which is going to be declared as IA at no earlier stage. Suppose at the time of when you purchase the shares in Mauritius in year 2010, 11, 12, whatever it is, what GAR will do? GAR will not lead to any taxation, because there is no income which is to be seen in the light of GAR. Only when the income is there and the object is to obtain tax benefit, obtain tax benefit when you are realizing income and you are saying that this is not chargeable to tax. It is only that when you say that this is the object is to obtain tax benefit. GAR comes in at that stage only. So whether
I
we
fully-
purchase it early years, that is of no significance, because GAR is going to be applied at that time when income is arising and the assessor is trying to take benefit of that. That's the only thing.
No, I fully agree with you, sir. We are absolutely, we are on the professional basis. We are only trying to analyze or
Yeah.
what we say implications of the decision. It is
Yeah.
going to be far reaching. If we take that view that every transaction of sale of shares is going to be examined, particularly if it's Mauritius, Singapore or Cyprus, any transaction is going to be treated with the test of this decision versus decision of Vodafone. What is the difference? That's what we are trying to implications, what could happen. That's what I wanted to bring in. 7 years, there also was the income. So again, just so sorry to deviate from, we can't say that capital gain is the issue. We are also saying the dividend was there. Dividend was taxed in Mauritius at concessional rate. Why? Because if you say that there is not owner is somebody else in USA, then go to the USA in that 2010 or 2011. So what I'm saying is, my point to request you to clarify was only from the point of view of Supreme Court's observations. And I agree with you, Supreme Court's observation that we have to consider the new section, amended section. So the old law, old circular is not applicable. That's why difference of opinion is only on that point. When can GAR be invoked? Your answer is right, absolutely. You're saying that capital gain, but it's not only capital gain. I'm saying entire income, entity, everything has been accepted as genuine entity for all these years, and suddenly you feel that only the capital gain transaction is for tax avoidance, and that becomes arrangement. That's a judicial. So we are only on the judicial GAR or JAR. Whether JAR is anything different compared to Vodafone. That was the point which I was trying to bring it out, sir. I think we can proceed. We will come out again with many other points are there. But sir, please, sir.
The answer to this, your point of view is that GAR is applicable on a particular arrangement, particular transaction only. So suppose assessee earned dividend income in this year or in other years also. That is not an arrangement. What is arrangement now at this stage when capital gain is being earned, and that is not offered to tax? When this is the only arrangement. In early years, you are paying tax on dividends. That doesn't mean this GAR is applicable on transactional approach, not on the assessee approach as an entirety. If suppose out of 5 transactions undertaken by an assessee in Mauritius, 4 are perfectly all right, but there is only 1 transaction which is falling within the ambit of GAR. Only that transaction will be hit by GAR. Others will remain as such. So
I understood, sir. Understood. So I'm saying we are tend to differ on the points on the approach, but your answer is right. That is also viewpoint, but I have slightly different viewpoint. But I think let us proceed with that. As a lawyer, as Rajesh and we are still lawyers, so we continue to when you are standing on the legs or arguing, we'll continue to bring out all facets. So get good judgments from judges like Sahal, sir. Yes, please.
So Rajan bhai, I think since we're talking about GAR, and we're talking about this investment arrangement, so Sahil sir has given some sort of, view on the point. Now the question is, Rule 10U1D versus Rule 10U2. Now, so 2-3 aspects there. So what is arrangement? I think we have discussed, and maybe we can discuss a little more. But again, what is the scenario that one is talking about? Because GAR provisions came into law only from 2017 onwards. So in any case, before 2017, there was no question of applying GAR. Secondly, so now what is it? Because when one reads Rule 10U1D, and again, that has been said by the finance minister that investments are grandfathered prior to 2017. But Rule 10U2 talks about without prejudice to. And then it says if it's an arrangement, then even prior to 2017, then it can still apply. So what is the situation that, with what is being held, then what is the situation where, because if it is anyway and not an impermissible avoidance arrangement, then it was in any case, GAR would not apply, so I wouldn't even need to go to Rule 10U. But so what is the situation where Rule 10U1D can apply, but not 10U2?
Yes, I think the answer to that is we find the decision itself. And when we look at the Shom Committee report, Shom Committee has, and they have referred to that para, but interpreted differently. Again, I'm not trying to criticize, but I'm saying how what was before the Supreme Court was Shom Committee report. Shom Committee has distinguished, we don't want to give open-ended blankets to all the transaction grandfathering. So we are recommending if there is any arrangement made, if there is any arrangement which is tax avoidance schemes, those need to be considered. But that does not apply to the investments made, which are bona fide investments prior to that date. So which is a categorical, and that we find that specifically has been discussed in the decision itself. But the conclusion drawn is only on the basis that Shom Committee also referred to like this. But according to me, my personal feeling is Shom Committee had very, very specific direction or specific suggestion as to what is the difference between arrangement versus investment. So now, just to again go back to the facts of the case, what is arrangement? Investment is not made in 2017. Investment is not made in 2018. Investment is there, and that is the same investment is continuing in that. So what is the new arrangement happened after 17? There is no new arrangement happened after 17. And the same arrangement, same investment is earning the income. Whether it is earlier dividend income, now it is by a capital gain. So sale of transaction cannot become an arrangement. What I'm saying is transaction is happened in 11. I have been continuing for 7 years. And before that is sold. So that does not mean arrangement. Arrangement is that there is something other things has done. Just before 18, I brought in Mauritius, assuming that grandfathering was not there, and I was to sell before 17. And 15 days before, I inserted Mauritius company. Instead of selling it from Cayman Island, I inserted Mauritius company. Yes, I strictly fall in judicial guard. Jar, I will definitely be covered because Vodafone says so. But that is not facts of my case. What basis government failed that this is arrangement, not investment? And that's exactly the issue which is being troubling. And which, according to me, Shom Committee report has been completely missed out or misread by while coming to the conclusion, and whether by AR or by the Supreme Court. That's what my personal feeling is. Yeah, Rajesh?
Yeah, I think the way that the Shom Committee had approached it, when they said that you can have a situation where something may be an investment, but something may be an arrangement, was that if I have let's assume for a second, a company without substance, which was established in 2010, continued making investments from 2011 till 2018 and made exits subsequently. What they are effectively saying that, listen, for the investments which you have made between 11 and 17, I will give you the grandfathering, but your subsequent investments, assume that I was earning dividend income and getting reduced tax rates, that I can still challenge on grounds of it being an arrangement. Because merely because you set up the company in 2010 does not mean that all subsequent investments will be grandfathered. That, to my mind, was how Shom Committee had looked at it to make the distinction. That's a distinction which does not come out, unfortunately, in how the Supreme Court has decided to view it. To say that, listen, I will look at when when I look at this transaction, ultimately, you're exiting post the grandfathering benefit has gone. This is nothing but effectively an arrangement. It is not a standalone investment that you're making, but this is effectively an arrangement without substance where you have essentially set up only to take the treaty benefit at the time of the exit. So in some sense, they have colored the difference between investment and arrangement, and you're going to have an ongoing challenge as to how do you make this distinction as to what is then meant by investment and when can you actually fall under the first provision, because that effectively has become in most situations redundant.
And this, just to supplement Rajesh what he said, this para 12.25 on page 90 of the decision has elaborately brought it. But the way it's interpreted, as Rajesh also mentioned, was slightly different than what is mentioned by the Shom Committee or the approach. And Shom Committee report only picked up only certain part. The Shom Committee report, if it is to be seen on GAR, it has to be seen in totality. We can't just pick up one paragraph in isolation and say that no, Shom Committee also said that like this. So I'm not saying that. So they're done. Approach what is saying to bring it to the GAR was slightly not within judicial GAR. That's what I have impression. Yeah.
That's Again, Rajesh bhai, I think Rajan bhai, you talked about judicial guard. So, Rajesh, I think I have a question to you. Now, the Supreme Court has held that, so it has gone on the principle that yes, guard could apply in this situation. Then it has said that, okay, even if guard does not apply, this judicial anti-avoidance rule, which is basically court-held, anti-avoidance sort of law of sorts, that can also apply. But now, when you do have, I mean, so can JAR, I mean, of course, the Vodafone did talk about, judicial anti-avoidance rules being applicable, etc. But that was prior to GAR coming in. Now that GAR, there is a codification of anti-avoidance rules that are there. Can one apply JAR? Because because under GAR there's a threshold that is to be met. There is a proper procedure that has to be followed by the revenue. So can JAR really apply now? Now that you have GAR provisions in play.
So at least on this point, I don't see a flaw in Supreme Court's argument at all. JAR and GAR can apply and can be applied in different scenarios. Obviously, there is a process and procedure insofar as GAR is concerned, but as a common law country, and judicial anti-abuse rules have been developed over a period of time. However, what you have to remember is that when it comes to JAR, it operates in a slightly different framework, and which is why I'm going back to say that, listen, you still have to meet the criteria on fraud, sham, device. You have to meet colorable device, to be more precise, not just a device, colorable device. So you have to put yourself into those particular buckets as compared to GAR, which is slightly different and has a different set of circumstances under which they can apply. So yes, will there be overlap in scenarios where you may apply GAR or JAR, and that's a right which is left with the revenue? Absolutely. But there will also be scenarios where you will necessarily say that, listen, I will have to apply GAR because JAR may not really fit into this fact pattern. So, but the right of the revenue to apply one or the other, to my mind, that is implicit in Indian law. And I think Sayal sir had pointed out some time back, where he pointed out the provisions of Chapter 10A, which very specifically say that this is over and above everything else.
Notwithstanding. And just to supplement, Sayal sir, before you step in, paragraph 48, what Rajesh said, just supplementing Rajesh,
Yes.
exactly spells out how parallelly both can be worked and what could be situation. So wherever, so JAR and GAR both have considered and they have explained in detail, and to the extent we are absolutely fine with what Supreme Court has said. So only question was which to apply. If GAR is not applicable, we can't, GAR is not applicable, we can't go to the terms of what is mentioned and they say, no, it is not applicable, but even otherwise I will hold it on JAR. Then what our submission was, that then JAR, right from beginning, it should have been examined, not the GAR submit. That is the point. Yes, sir. Sorry, sir. Sorry.
Yes, you rightly said, Mr. Vora, that para 48 deals with this issue. In para 48, this is that GAR and in the alternative JAR.
JAR, correct.
So initially, what is to be applied is to GAR, and if GAR is not applicable due to one reason or the other, then JAR has to be applied. But the fact of the matter is that if a case is governed by GAR, then JAR cannot be applied. Because take a simple situation. Suppose there is IA, but tax effect is less than 3 crore. If you go with JAR, means jurisprudence, this legal substance over form. If you go with that, then of course this would be hitting that transaction. But since GAR is there, and GAR is giving benefit to income below 3 lakhs of rupees, even if IA is there. So in that case, I think only GAR will apply, JAR won't apply. But where GAR cannot be applied, GAR is inapplicable. Not that it is applicable but doesn't apply. Where GAR itself is inapplicable, in that case JAR can be applied. But since now the GAR is there, so it will primarily be GAR only. That is why Supreme Court said GAR and in the alternative JAR.
Correct.
Not that JAR first and then in the alternative GAR. Primacy has been given to GAR.
Absolutely. So only one supplementing to sir, your point is, if we accept that it is not arrangement or investment, let's keep that difference of opinion on the part what is the arrangement. If we come to the conclusion that it is a grandfathered because of the GAR provisions, then necessarily they have to go up to JAR. As I said, there could be difference of opinion whether it is arrangement or investment. Department in all cases will try to say that everything is arrangement. There is all investments made through Mauritius are arrangement. But if we suppose on the judicial principles, we say that no, it is not arrangement, it is only investment and properly justified in all these ways. Suppose earlier cases I have sold some shares. Let's take a hypothetical example. Between 11 and 18, I have sold some shares before 17, which is accepted by the Mauritius authority as well as the Indian authorities. Yes, it is a genuine eligibility and everything. If that is the situation, then large chunk of the shares is sold after 17 will not convert that investment into arrangement only because some portion is there. In that case, my submission is, in that situation, if you have accepted me as a genuine investor, investment, then only JAR will apply, not GAR, because then grandfathering provisions will apply. I think that's what I was just trying to summarize, sir.
So when we see the facts of this case, in this case itself, the Tiger Global case itself, the assessors were offering income to tax. Dividend income was being offered to tax. It's not that they were unaware of the fact that the income was being offered to tax. Despite all this fact, when the Supreme Court has held that GAR is applicable when the transaction of sale is taking place. So, they were also perceiving it as investment earlier. For all the years, department accepted it like that only. And now when at the time of sale has arisen, and GAR has been applied and Supreme Court granted its stamp of approval to that. So, to my mind, it will be very difficult to contend that if earlier it was investment, earlier dividend was taken as taxable, now you can't apply GAR, because it is in these facts only that the Supreme Court judgment has come.
No, I agree, sir. I absolutely agree. So I'm saying how implications, we are only considering implications. Implications, if we analyze each and every investment made prior to 17 in the lens given by the the Tiger Global, then everything will become arrangement. Everything will become arrangement. Even though earlier, as I was giving example, some shares are sold in between earlier sold, which is accepted as a genuine investment. Capital gain is exempt, treated as exemption. Only because some shares are sold after 18 will it become arrangement? That was my question.
So, you see, Mr. Vora, this has become arrangement because of the other reasons. Because the entity in Mauritius, means the assessee, was not actually doing some business or control. It was only routed from USA. That is the only difference. Suppose the entity had been in Mauritius doing everything at their own. In that case, it would have remained investment. Now, suppose it's not that it is now universally applicable, all the investments made through Mauritius are going to be hit by this judgment. Suppose the assessee proves this case that the Mauritius entity was genuinely set up and it was doing its business, management control was with it only, then this GAR won't apply. Then the ratio of this judgment will not apply.
I agree. We beg to differ on that, only proceed, sir.
Right.
And there is one more silver lining in this judgment, because you see that all through it in the past, the controversies were arising that I am holding TRC, so I should be given benefit and all this. Department was denying benefit. Now with this judgment, what has happened? What has emerged? That if only GAR is applicable, then only TRC will not be examined, have to be examined afresh. It means in all other cases at different stages, now they will get benefit of simply holding TRC would be enough, because when GAR is not applicable for the early years at different stages of appellate proceedings, they will be getting benefit because Supreme Court has held that is only in the light of GAR that TRC is not enough. You have to go into all this.
Sir, slightly, because that next question, later question is there. Since you have touched that point, but how do we read subsection 94 and subsection 95? Because 95 says if is not elaborate, your TRC is not elaborate, is only futuristic and everything. So all those terms they have utilized. If that is so, then we have to give all information as prescribed in 95, irrespective of GAR. I don't need to go. Even to claim exemption, I have to satisfy 4 and 5 together. So therefore, GAR, what you say is right, but GAR, without even GAR, this situation will come now. And again, TRC, again, sorry, sir, again, TRC is each year. It is not that once given 2011, it will continue to be applicable to us. Every year, I have to go back to the officer, that officer who assesses me and then issue TRC. So if that is the situation, if Mauritius law says your TRC is valid, you are a tax resident of Mauritius, I'm taxing your income in India, in Mauritius, and then our dispute is if GAR applies. If GAR is not applicable, if it is grandfather, then what is the situation? That's what I think the situation is. And asking for information on 4 or 5. So my respectful submission is, in all cases, wherever I'm relying on TRC, I will have to give all the information in 4 or 5, and this will create more difficulty because of Supreme Court's observations. The TRC, for these reasons, we are saying that no, it is not proper.
So my answer is that the residence test has to be seen in the light of Article 4 of the DTAA, right? This article doesn't say that if you are holding TRC, you become a resident of that state, right? This is one thing. And second, Section 90 subsection 4 and Section 90 subsection 5. See, 90 subsection 4 is negatively couched.
Yes.
See the language of this section.
Yes, yes.
It says no benefit will be granted unless you are holding TRC. It doesn't say that if you are holding TRC, you are entitled to benefit.
Absolutely.
So this is necessary condition, but not all in all.
Absolutely. Absolutely.
And Section 90 subsection 5 is extension of Section 90 subsection 4 only. That in addition to holding TRC, you need to file those respective forms also.
Absolutely.
So Section 90 subsection 4, Section 90 subsection 5, they only say that you must possess TRC. This is one condition, and they don't say that these two sections do not say that by holding TRC you become entitled to the benefit of detail. For that, you have to go back again to Section Article 4, which says that under the domestic law.
Absolutely.
Residence as per the domestic law.
Absolutely. So, Mahesh, depends on time, you decide which
So,
questions to be now taken. Because we have slightly behind schedule.
Yes, sir. So with the time, I think so there are a couple of observations of the Supreme Court, not on the anti-avoidance part. So I would like to, take those, if possible. So to Rajesh, the question is, in para 18, there is a observation that indirect transfer is not covered under the DTAA. Now, how do you really read that? Because Article 13(4) is effectively a catch-all provision for capital gains. So how do you really, interpret this kind of observation of the Supreme Court in respect of indirect transfers?
So I think you have to look at the particular statement that was made in the context of what has been argued by the parties also. At no point did either the petitioner or the respondent ever deny that Article 13(4) would not apply, but for application of whether GAR or JAR. The ASG's own argument was that this is a transaction which falls under Article 13, paragraph 4. Under those circumstances, I think what paragraph 18, what the judges are talking about is to say that, listen, it is not an automatic situation that once there is an indirect transfer, that you are entitled to the benefits under Article 13, paragraph 4. Which is why they use the word that it's not at threshold. Which means that I just go in and say that, listen, it's an indirect transfer, Article 13(4) applies. No, you still have to meet the other criteria. What are the other criteria? You still have to show that you are a resident of Mauritius. And the second one you have to prove is that the transaction which is there refers to you actually transferring shares of a foreign company whose value is derived from Indian assets. I think that is the way and that you have to read that particular paragraph. And that is also fortified when you see paragraph 50 in the conclusion. Because in the conclusion, they actually say that I'm going to deny you the benefit under Article 13, paragraph 4 due to application of Chapter 10A. If the Supreme Court wanted to say that indirect transfers are not subject to the benefits under Article 13(4) in entirety, the judgment would have stopped at paragraph 80. There was nothing more to say after that. But they have gone into this to say that, listen, it is not unlike Article 13(3)(a), 3(b), where I have my LOB provisions, all of those start coming into play. This is not a this is not a situation. This is an absolute provision, but absolute provision now we are going to read in the restrictions in terms of what is the test you have to meet. I think that is the way to actually look at the provision,
So,
the statement made by the court.
Later, when we say Supreme Court says, I read down the law. Here we have to read down the Supreme Court decision, what we can understand from the decision. Yeah, proceed, Rajan.
So to Rajan bhai, to you, there is another observation again by the Supreme Court which talks about non-taxation of the transaction in Mauritius. Now, is that really a factor? Because GAR or JAR you're talking about in terms of avoidance of Indian tax. So does it really matter? Or and again, you have had Azadi Bachao and there are various other decisions you talk about liable to tax, etc. So is that something that does the interpretation change because of the Tiger Global decision?
No, again, sorry, as again Rajesh was mentioning, I think we have to see in the context in which these observations have been made. That is not the ground on which ultimately the decision has been taken or ultimately findings have been given. And that has been clearly brought out in paragraph 49. If you see the paragraph 49, they are saying liable to tax is, I would say loosely said, liable to tax is not something which is tried to say that liable to tax means it should be taxable there. So I think we'll have to read in that line. As I jokingly said, reading down, I think we'll have to read down some of the provisions. Sorry, to understand the correct what Supreme Court is trying to convey. So therefore, implication wise, I don't think so there is any change of position as in Azadi Bachao or Vodafone. Liable to tax remains same. Chargeable tax, liable to tax remains same. You need not pay the tax there. In this case, they were paying tax. Not that capital gain should be taxable there. Right. So way the whole flow started is you are claiming exemption in India, you are taxable in India, but you say that you are exempt under 13.4 and you are not paying tax in the Mauritius. Therefore, somewhere they wanted to say there is double non-taxation, but that didn't use the word. But point is this, both places. So is it not tax? So the very loosely we use words saying then liable to tax. So according to me, there is no change or there is something deviation made by Supreme Court. That's what my personal feeling from the earlier what has been said. Yeah. Sir and Rajesh.
And Mahesh, I think the court does actually use liable to tax at one place in paragraph 49, where they say that you have to be liable to tax for you to get the benefit under Article 13, paragraph 4. They misquoted the paragraph number, but paragraph 4. So I don't think they are deviating or they intended to deviate from liable to tax as a concept. So whenever they have used words like taxable, I think they have always meant it as liable to tax. I don't think that, and I don't think that has been pressed either before the court.
Yes. Yes, please, sir. Please go ahead, sir.
Yes. This discussion, this has two components. One is based on para 18, and it has been inferred that indirect transfer is not covered under the DTAA. But when we read the para 18, it is only 3-4 lines. First line of this para 18 says that on a combined reading, it seems clear that for the benefit under Article 13.4, the person claiming treaty protection must not only qualify residents, so and so, so and so. This is first line. This talks about Article 13.4. And the last line, thus, an indirect sale of shares would not at the threshold fall within the treaty protection contemplated under Article 13. They are not saying that it is under Article 13.4.
Correct.
They are saying it is not covered treaty protection. Now see, there's a difference between treaty protection and the amount getting out of taxation in one country. So because of Article 13.3a and 13.3b, the assessees are getting treaty protection that if you are holding shares before 31st March 17, then when you are sell shares, those won't be subject to tax. If you sell within those 2 years, 50% tax. This is treaty protection. And what they are referring to is that what they're saying is that this 13.3, 13.4, that is only relevant for the other purpose. For this treaty protection, what they're saying, thus an indirect sale of share would not at the threshold fall within treaty protection. I mean, indirect sale of share would not come within the ambit of 13.3 and 13.3.4. It will remain of not 13.3a and 13.3b, but of course it will remain under 13.4. This is catch-all clause. This is one thing. And second thing which we were discussing about the liability to tax, what this Supreme Court does, it should be liable to tax. let's see what Supreme Court has said. Supreme Court has said in this judgment itself, para 19, what they are saying is that the object of DTAA is to prevent double taxation and to facilitate avoidance or evasion of tax. Therefore, for treaty to be applicable, the assessee must prove that the transaction is taxable in its state of residence. This is what they are saying. And then they are saying only if the assessee is liable to pay tax in Mauritius. They are contemplating the issue of liable to pay tax in Mauritius, then he can derive benefit under the provision of Article 13C of the treaty. Now, see, this liable to tax has been defined under the statute. Section 229A defines the term liable to tax. And you see, just look at the definition of liable to tax. It says liable to tax in relation to person means that there is a liability of tax on that person under the laws of any country. Number one, the person should be liable to tax on that income. And secondly, a case where subsequent to imposition of such tax liability, an exemption has been provided. Means at the threshold, at the beginning, the income must fall within the tax net. And if after that exemption is given, it is treated as liable to tax. But under the Mauritius law, capital gain on transfer of shares which are held as investment, that does not fall within the tax net itself. These gains are not considered taxable income rather than being included and then exempted. These are not considered as taxable income. What Supreme Court is saying, that is in sync with the definition of liable to tax, that you should either be liable to tax or after liable to tax you get exemption. Not that you initially you do not enter into taxation. Exemption is given only when taxability is determined. If taxability is out, there can't be any cost of exemption. So exemption means firstly the income is taxable, then exemption is being granted. But Mauritius Act, it does not include capital gain on transfer of shares held as investment as income. Of course, it treats income from sale of shares held as business as taxable. But investment of shares, it is not included in the income that at all. So there is no cost of exemption. So what Supreme Court has said in these paras about non-taxability, that is in sync with 229A, definition liable to tax in India. That is the point.
Right. Sure, sir. In the interest of time, I think, we have only about 15 minutes or two. So quickly, I think, and I think two critical questions, in terms of implications or ramifications that one is talking about of this judgment. So first to Rajesh, how does this decision really impact? Because, as practitioners, there are remittances that, that are, I mean, aids from the deductor perspective as a chartered accountant when one is certifying the remittance under section 195. So what are some key factors, what are the documents that one needs to look at? I mean, how does this decision really impact a general practitioner in this situation?
Sure. So, and let me take the first threshold question, right? When a CA is giving a 15 CA and or a CB report, they are not sitting in judgment over the transaction. Ultimately, that judgment is that of the revenue. Second is that they cannot apply GAR to determine anything around 15 CACB because that's a statutory process which has to be undertaken by the revenue through referral to the panel, etc. So and if I take Sayal sir's argument further, where he says that, listen, you can only apply GAR in scenario of no TRC, then it actually makes the job easy for the CA. However, I would say that, listen, even if JAR applies, and that is no different from even today, all your transactions, people generally look at JAR when you're doing your report filing. So obviously, from a CA standpoint, they have to do the simple checks and precautions to ensure that, listen, am I falling within, am I getting the right representation? Because they're not, it is not a forensic job that they're doing. It is a diligence job that they're doing, saying that, listen, are there basic checks for everything still? Does it meet? Yes. Have I got the right kind of confirmations from the management? have I looked at any documents which I feel is appropriate, basis which they've given the certificate. But I don't think you can ever look at it as saying that, listen, they are going to sit in judgment to decide whether, oh, should GAR apply and all. I don't think so at all. So I don't think it is as material a change from a CA standpoint as they would otherwise think.
Thank you, Rajesh. I think.
So sorry, just to supplement Rajesh
Yes.
from the certificate. Before that, Sal sir, will it make a difference? Because if you see the definition of liable to tax has 229A has come from 1421.
Yes.
We are talking about situation of 1819.
But
So in that context, we are saying the Supreme Court what they are trying to do to 229, they are not referred also. But I'm saying that may not be the correct interpretation, saying that what Supreme Court said is on the same lines as 229A. That was my just thought for consideration. Okay, coming back to Rajesh's point. So I would say diligent charter accountant would not only have to see that it is prima facie, it is there, but he has to prepare a checklist, right? From asking every time when he is issuing certificate for any tax treaty country, as to when was company formed, when is investment made, where is the board of directors, what are the meetings. So he must have at least 20 points checklist, satisfy itself. It should be part of that report. This is what I have checked in. This is on the basis of which I have come to the conclusion that this is prima facie eligible for deduction under whatever the treaty benefit. So I'm saying he cannot simply now sign certificate saying that yes, treaty benefit is available to that. It is not possible. He will have to go through the checklist, and there are enough checklists. If you see earlier decisions, and those who are interested in study, what they should do is starting from Vodafone, Azadi Bachao to Vodafone, there are at least host of decisions of AR, wherein all these factors have been brought in. Whether it is SPV, whether this is money has come in the bank, whether any new investments have been made from that money which has come, income has been done, is there any borrowing made, borrowing has been repaid by that Mauritius government. So all those factors to prove the commercial substance. So all those factors, you must write it down, keep it in the file, and how much to disclose in the certificate can be taken care of, because it may not be uploading may not be possible, but whatever is required to be done, he must have that exercise ready. He cannot now take it saying that yes, based on jar, I was saying that is not applicable. So it may not be possible. He will have to be extra cautious now.
Yes, certainly.
So Rajan bhai, another implication.
No, sorry, just to International Tax Committee, I think just as a facility or service to the members, I would request at least some small group to be formed as to what are the certifications benefits to be, how charter account should certify this 10, 15 CSEB or CB, because that will be really helpful.
Confirmations. There has to be standard confirmations.
Like tax audit reports time, sales sir will remember we used to get that standard confirmation. So there has to be proper confirmation from them, and he has to have test checks carried out on all these confirmations, not again simply following certificates and confirmation and proceed further. So therefore, as a BCA, we should come out with some small guidance note to all those who are, because now that volume of transactions have increased considerably. So therefore, it is always good to have. And even though Mauritius investments may have reduced, but transactions which are exempted at 13.4 will continue to happen. Other countries will happen. So therefore, while issuing certificate, we have to be extra cautious. And BCA International Tax Committee should give guidance to the members. This is a guidance note, what we call guidance note for issuing 15 CSEB. Yeah, please. Sorry, Vash.
So another implications that, now we talked about, from a practitioner's perspective, now moving to the taxpayer, what happens, where there are other matters which are pending at any of the forums, would there be a reopening? Would there be if it is, there can be different baskets, right? It could be pending, it could not be pending. So would there be a reopening? Can there be a rectification under 263? Because, again, there are certain newspaper reports where CBDT has said that it will not reopen on these factors. But what do you think would be the implications for the taxpayers other than Tiger Global, obviously, on this kind of decision?
No, I think very, very good question, Mahesh. And in fact, Rajesh was present. There was a seminar 2 days back of organized by IMC, BCA, and CTC. CCIT International Tax had come for the meeting. And because earlier discussion, this Tiger Global issue had come up when the session started, and other higher decision, Tiger Global, Binny's case, so that we were discussing that. So she started her speech saying we have been discussing at the board level, and board has taken a view that we will take it very pragmatic view and it will not trouble the taxpayers in general. This is what a general statement. I'm not exactly paraphrasing, but this is what assurance she had also given before she started her opening speech. So therefore, looks that there is some thinking going on, or I think they are looking for this as only set aside matter and going back to the officer and to start investigation. But whether that will be there or enthusiastic officers will start looking into Supreme Court judgment as a Bible and start everything, we don't know. We'll have to wait and see. So that is as far as the that assurance is concerned. Now coming to the very three important point, whether it is mistake apparent from record. I think that's one part we should consider. Second part is whether cases could be reopened under Section 147, and particularly the law as amended from time to time. And really, I also many times wonder what is the law applicable today, because that's the way so many amendments have taken place after 21. Every year there are some amendments and we have to examine that. And third is 263. Again, there are lots of amendments made into 263, but fortunately 263, last amendment was 2016. Thereafter, there are not many amendments in 263. So these are three sections we have to examine. Now, as far as the 154 is concerned, I think there is a recent decision of the infrontis decision of Bombay High Court, which has specifically said subsequent decision of that is in context of tribunal order, is not connected to assessment order, but tribunal order. They say if tribunal has passed or based on certain earlier orders, that cannot become mistake apparent record merely because subsequently there is a Supreme Court decision has come contrary to that. That's a decision which has been followed in other Prakash Kohli and Vaibhav Domle's case. So there are these three decisions are there, and this was in particularly after Supreme Court decision in Checkmate's case, where this issue was whether it will be cases could be reopened, but that decisions are restricted to Section 254(2). It is not general section. Now, question is, suppose matter is already heard by CIT appeal and his order is not passed. Can he use it? Yes, he can use it. That is part one. If order is pending before assessing officer, he has not passed the order, whether he can do it, he can do it. Whether tribunal is pending before tribunal can also have a look at the ratio laid down. So that all can happen for pending matters. But completed matters, as far as tribunal is concerned, High Court has given categorical finding. So High Court is very clear on that point. When it comes to the CIT appeal, will it amount to mistake apparent from record or officer will happen? It's matter for to be debate, but I think ratio of the Bombay High Court could be useful to us to say that when decision is given on the particular day when the law as was pronounced or as was prevailed by the various courts will be looked into, and not subsequent decisions which will happen. Saurashtra was in the different context. Saurashtra Supreme Court was, decision was there, but it was not referred to by the council to the tribunal. Therefore, they said it's mistake apparent, but not other way around. So therefore, as far as 154 is concerned, I think that's my view. I will request Sahil sir to supplement, but I'll complete 147 and 263 and then we'll request Sahil sir. As far as 147 is concerned, judicial precedences, all the decisions, are there any furnishing of inaccurate particulars or incomplete information has been given, or there is not full and true disclosure made by SSC? Now, in these cases, there is no question of full and true disclosure. Everything is disclosed. Facts are all available on the record. So there is nothing which is left out. So now the question is, all the decisions which are there are under the old law prior to amendment in 21, and which says 4 years and 6 years. As far as 4 years concerned, there are open views to both sides. Views are available, but as far as beyond 4 years, they say there is no nothing has been left out. Nothing has been not disclosed by the SSC. There is no failure on the part of the SSC. So therefore, on that basis, they say beyond 4 years, so nothing can be done. But 4 years, there are for and against decisions, but more decisions in favor of the taxpayer, saying that it is not a reason for the reopening, merely because subsequent Supreme Court decision has come. That is as far as the reopening is concerned. Now, interesting point arises is there are two or three new clauses which are added in the 21 or 22 or 23, I don't remember. As to 148(3)(2, it says any audit objection done, that case has not been done in accordance with the provision of the Act. Whether this will amount to the order is not been passed by assessing officer based on the Supreme Court decision. Here also, my personal feeling is, if Supreme Court order was there and he has passed the order ignoring Supreme Court, then this will apply, not the other cases which is already passed and subsequent Supreme Court decisions come. So therefore, even this will not apply. The next is any information which requires any action in consequence of order of High Court or Tribunal. Again, this is not related to general order, but it has to be in your own case order. Then only this can apply. So therefore, again, these new conditions also will not be helping department to reopen under 148. That is number 2. Now coming to 263, as we are aware, there are a number of decisions on 263, Max India and everything. Any subsequent amendment, they say there is nothing which was, what commissioner has to see when the order is passed, what were the facts and decisions available before the officer. Subsequent decisions cannot become order which is prejudicial to the interest of revenue. So that is what decisions are there. Only slight worry is explanation 2, clause D, which says order is not in accordance with the decision prejudicial to the assessee rendered in judicial high court or Supreme Court. Now, again, my submission is we can say that this has to be there when the order, AO passed the order, not subsequently, when commissioner is examining. So there also, again, 263, according to me, cannot be invoked because everything has to be seen when the orders are passed. And so neither 154, nor 263, nor 147 can be invoked on this fact. That's my Rajesh and Sayal sir.
And Sayal sir, before you come in, I'll just take 1 minute. I think the one thing that we have to keep in mind, and I'll give the answer to that also, is that when it comes to Supreme Court declares the law. And when you say Supreme Court declares the law, it is the law as it always stood. It is not creating new law. So which is where it starts getting slightly tricky.
Okay.
But I think, and people should take the time, there is a Justice Kapadia's judgment in Simplex, where he has actually dealt with this issue, where saying that a subsequent Supreme Court decision which overruled a High Court decision, and he said that no, this I'm effectively treating it as change in law, you cannot do a reopening, etc. basis that. So that actually gives a pathway where even though Supreme Court declares the law and it is law as it always was, you can still have precedents at least where the Supreme Court itself has said that listen, I'm still not going to use that as the reason because it is nothing but actually potentially see it as a change in position.
Yes, Sayal
sir.
Again, you will find me a little bit at a different stage. But anyway, I'll be giving you this perspective, whatever worth it is. See, Supreme Court always declares a law, rightly said. Declaration law is always retrospective from the time when the provision was inserted. It is not legislation by the Supreme Court. So once Supreme Court has decided a particular issue, it is to be presumed that this was the law from the inception. And any order which is contrary to this law will be wrong, requiring ratification. This is one point of view. And other side, you rightly said that there are some Bombay High Court judgments are there, 1-2 judgments are there, in which they have held that judgment has to be seen, means mistake in the order has to be seen, and the date at which the order was passed. If at that time the judgment was not prevalent and judgment has come later on, in that case rectification cannot be done. So the point to be noted is that while holding so, this Bombay High Court has relied on 2-3 judgments. In fact, those 2-3 judgments were in the context of review by the Supreme Court. And the scope for review by the Supreme Court is quite different from ratification by the tribunal A or whatever it is. So wherever we stand, means right now there are two views which are existing. One is for, one is against. This is the position. Means it can't be said that it is either for or against, because there are several judgments of the Supreme Court contrary to that also, that if judgment has been passed, it is from inception of law, any order contrary to that requires rectification. And there are judgments, Bombay High Court, which you that rightly said, that which has held otherwise also. Now it depends upon how the department takes it up. Where it is, of course, if the department starts with 154 proceedings, there is the scope for this SS to means have some scope for proceedings there. This is regarding 154. Regarding the reassessment aspect, now only two limits are there, 3 years and 5 years. The law which stands now. Now suppose if they have to issue notice today, law prevailing as on date will be applicable. As on date, under this Finance Act 2025, this only two limits are 3 years, 3 months for 148A and for 148 and 3 years and 5 years. Means 3 years, 3 months, 5 years, 3 months for 148A and for 148 is 3 years or 5 months. 3 years or 5 years. So the fact is that this, under the new scheme of reassessment, the earlier position doesn't now stand. That earlier it was declared, it was not my mistake, you should have done this, you should have done that. Now what is this? Now 148, entire 148 is based on the assessing officer getting information which suggests that the income chargeable to tax escaped assessment. If a particular case falls within the ambit of this, then automatically reassessment has to start. And this has been defined in 148 subsection 3. And in this subsection 3, there are 5 clauses given. First clause is where any information in the case of the assessee for the relevant assessment year in accordance with risk management strategy comes to notice. And the fifth clause is any information which requires action in consequence of order of a tribunal or court. But the here point is that whereas in clause 1, what they are saying in the case of the assessee, but for clause 5, where they are reference to case of the order of the tribunal or court, they are not saying that in the case of the assessee. This is the distinction which we have to bear in mind. 1 specifically talks of the material in the case of the assessee, and 5 doesn't talk of this. So this we need to keep into consideration while contesting. So this is about this. And 260, this 154 period is of course 4 years from the end of the financial year in which the order was passed. Of course, suppose order is passed after 2 years like that, so you get more leverage, more time to reopen, to rectify it. But depends upon the facts of each case, where that case stands. Means what may be beneficial for a particular assessee from the point of 154, that may not be beneficial to the other assessee. It depends upon the facts of each case as to which provision is applicable, and secondly, which provision is invoked by the department. So this is another thing. Regarding 263, again, there's a period of 2 years. And one view which you rightly said, that if the judgment was not existing when the order was passed, then revision on that basis is difficult. But there is equally another view also, which defines record. Record means record available at the time revision is sought to be done. So record will include judgments for and against portability. Again, there are two views depending upon the fact which way the proceedings are started by the department. But for the completed assessment which are already in litigation, of course, wherever in these assesses for which the decision has been rendered by the Supreme Court, and for other litigation cases where the matter may be pending at different levels of the appellate proceedings, some ITAT, High Court or Commissioner level, everyone will be following the Supreme Court judgment. Nobody will dare to go here and there. So once this judgment is considered and the order is passed in that case, what will happen? What will happen that the matter will again go back to the assessing officer. So there is no time limit. Unlike 147 containing time limit under section 149, 5 years later, this is for the new reassessments to commence. For the completed assessments which are already in litigation, there is no time to commence the proceedings because it is always pursuant to the direction what High Court or Supreme Court has said. So time limit is there for completion of the assessment, not for the initiation of the reassessment. This is all what I conclude.
Thank you. So I think as a concluding,
Sorry, you have how much time you have?
So we have passed actually the time.
Okay.
So
just if you want to take few questions, I think if you have general questions, we can take. If it is fact specific, I think we will not be able to touch upon because the chat shows 15 questions.
So a lot of it has actually been covered, as well. Talked about indirect transfer, JAR, etc. So I think if we can this thing. So also one more point. I think one point that was raised in the chat is in Mauritius, residence is based either on incorporation or control and management. Now the point is there a view that has the Supreme Court ignored this aspect, or because then for me to be a resident, even if I'm incorporated in Mauritius, like you have in Section 6 in the Income Tax Act in India, I'm considered as a resident in Mauritius. So would that, can that have an impact on the decision?
Rajesh, you would like to take? Rajesh?
So I think there are two parts to this, right? What does the Supreme Court say? Supreme Court says that I have the right to determine whether the SSC qualifies as a resident. When I say I am saying Indian Revenue has the right to determine and interpret the law of Mauritius to determine whether you are a resident of Mauritius and you meet the test or not. As a matter of private international law, and if you go back to TechNIP and there is a lot of other judgments, the law is actually very clear that questions as to residence, domicile, etc. has to be determined as per the law of the country of residence. There is a slight deviation from that where they have said that no, for you to apply and I think they are reading it in the context of anti-abuse rules, not as a general principle. And that's how you have to read it. Say that for the purposes of determining for application of anti-abuse whether you are resident or not, I will go into much more fact-specific analysis. I think that's the way to read the judgment.
Right. Absolutely. I think I fully agree.
No, I also fully agree, but just I want to add one thing, that the test to determine the residency under the Mauritius law and Indian tax law is same. Both talk of management and control. And what the Supreme Court said is that the certificate given by the Mauritian authority is not in sync with their law.
Right.
So that is the point. So that is why they have authorized the Indian authorities also to see whether management control is there in Mauritius or not. That's the only thing.
So I think there the one challenge is that should it ought to be the Indian court's responsibility to determine whether Mauritian tax authorities work within the Mauritian framework, and which is why I tried to narrow it down to say that that has to be limited to cases of anti-abuse, not as a general principle.
So as concluding remarks, I think, maybe as a quick answer, first from the panelists and then from the chair, what, in terms of the facts in case of Tiger Global, what if something was different that, you think that the decision of the Supreme Court may have changed? And I think obviously we have discussed this, in terms of principle, but in terms of specific facts, there is a question also that what if the pooling vehicle itself here in this case was in Cayman Islands, what if that itself was in Mauritius, would that have made a difference? What if the investment directly was in India instead of through Singapore? Would that have made a difference? What would each panelist, what is your view? So quickly, I think if Rajesh, if we can go to you first.
So if you ask me, I think the one thing which turned it for them is the signing authority. I don't think anything else moved the needle as much as the signing authority did for them. And I think that's where they got troubled around it. Obviously, there were a lot of facts that were placed both before the AAR and the High Court. It has not, none of the facts have really been, if you look at it, been referred to in the order. But the two things that they referred to was one was on the beneficial ownership and one was on the bank account signing authority. And to my mind, it has to be the bank account signing authority because they were ruling on the place of effective management, not being elsewhere. So I would have thought that is really the only the point which shifted it for them.
Absolutely. I think, Mahesh, I fully agree. There are other point which we need to consider is this is not the only case which we need to decide the test whether this is right or wrong. I would say everybody whoever wants to learn on this should go back to all the decisions which are there given by AR, which are reported decisions. And you will find out lots of tests laid down by each of the case, which could be useful for JAR. I may or may not be applicable to CAR, but JAR definitely it will be applicable. And if we are able to establish all these tests have been satisfied, commercial substance is there. I have been operating from there, and it's not something only a pass-through entity that money comes there and immediately gets passed on, and then nothing remains there except the bank account. I think if that is the type of situation, definitely it would be there. But I would strongly feel, and unfortunately, fortunately, there are two decisions of AB Mauritius. If anybody is interested, I think that lays down what is the difference between eligibility and non-eligibility. Because both orders are passed on the same day. One was Mauritius has been AB Mauritius has been held against, and AB Holding has been held in favor. Because this is exactly as Rajesh mentioned, fine distinction has been made about the signature, company formation, who was under control. So therefore, fine distinction of 2 or 3 facts have changed the decision factor. So therefore, I think whoever wants to really make the in-depth study, I think he should not stop only at this judgment. He should go backward and see the decision. There are a lot of insights you get. And because I had happened to argue many cases, so I know exactly how court ARs were at least looking or tribunals were looking at, and that was helpful. Yes, Raj.
Thank you, Rajan Bhai.
And
Yeah,
that's
Rajesh.
why, if you remember in Tiger also, on the same day, because there was both Mauritius and Singapore, which was before the AAR, there was a positive ruling in Singapore where the matter was admitted, and negative ruling in Mauritius where it was not admitted.
Right. So I think before we hand it to the organizers, we'll request the chair, RSL sir. So 2 points. I think one is, if you have, what do you think in addition to, Rajan Bhai and Rajesh, what they have mentioned in terms of any facts that could have been different, that could have had a different implication or different decision from the Supreme Court? And sir, for your concluding remarks. So over to you, sir.
So in addition to what Mr. Rajesh has said, that the signing authority played a crucial role. In addition to that, another factor which also played a crucial role is that they were seeking guidance or investment advisory only from the US entity. So that also played a quite critical role against the SEC. Once the entire advice is coming from the US entity, the ultimate parent entity, so that led to the position that there is in fact no management and control in India. In addition to what he has already said, that entire signing authority was not with the local directors. So number of directors is not conclusive. In that case, 2 directors were from Mauritius and 1 was from USA. That is not crucial. Number ratio of 2:1 is not crucial. What is crucial is what is really being done and where from it is really being done. If you have 3-person directors and you're holding board of directors meeting here also, but everything is coming from abroad, your ultimate parent entity by means of advice. So that is of not much assistance. The thing to be seen is that what is really and where from really the things are being managed. That is means in a sense it is management and control which is the essential thing to really come out of this. And
So, please, sir.
Yes.
No, please go ahead, sir. Sir, please go ahead, sir. Please go ahead.
Okay. And regarding other factors which we should take into consideration, I think most of the factors are coming out from the judgment itself. This is actually a wake-up call.
Yes.
Wake-up call in the sense that we now need professional need to ensure that if you are seeking the benefit of the treaty, it should be there that management control is established from the concerned enterprise, concerns that country only. So what you can do for that, you need to have the real and effective overall control and management, what they say head and brain. And in addition to that, what this has been, AR has noted all the things against us as he signing bank authority was with that person, Mr. Coleman was signing authority for all the transactions exceeding $2.50 lakh. So that has to be given to those concerned country persons representative only. Another factor, important factor, what they noted is that in that case, global assets were again in the name of Coleman. Global assets for the Mauritian entity was obtained by Coleman, and he was shown as beneficiary in the bank accounts. When all these factors are seen in totality, we need to be very careful that all these such type of factors should be avoided. That's the only thing.
So, later when I can only say there is a competition going on between the courts and the legislation who makes unsettling the law more, and that is at least the brighter. I would say for professionals, the brighter readers here at the cost of the taxpayers.
Right. Thank
So
you.
Each case needs to be analyzed very properly because it may be at different stages of litigation. One needs to analyze the case very properly as to what can be taken from this judgment if actually it is there as per law. That's all.
And Sal sir, as you rightly said, each case has to be put on the first checklist. As to the checklist, hygiene, what we popularly call hygiene test, before we really would start looking at the case. First, check the hygiene text and then look to the case.
Yes.
Yes.
Thank you, Sal sir. And on that note, I would like to thank the panel, CA Rajan Vora, Advocate Rajesh Simhan, and our chair, Advocate R.S. Sahal sir. I think fantastic, a lot of thoughts on this Tiger Global decision and its ramifications. So thank you so much. I, for one, have genuinely enjoyed and have learned quite a bit. I think we'll need to go back and read again the decision in the context of what has been discussed today. Thank you so much. And over to the organizers, Somya, to Ritvik and Jagat. Thank you.
And a thorough and excellent exposition. Many thanks to all the panelists and Mahesh, particularly for moderating this excellent session. Before we conclude, Jagat, if you can make a couple of announcements, or you can directly go for the vote of thanks. Thank you.
Sure. I'll just make a short announcement, like a minute or so. Friends, the International Tax Committee of BCS has a schedule a couple of very interesting events. First is in line is we have a brain trust session which is scheduled on 28th of Jan, wherein we'll be touching upon or having a discussion on various nuances of international taxation. Followed by that, we have another interesting conference in the form of International Tax ITF conference, which is scheduled on 9 to 11th April, and it is at Indore. The brief information of this conference is there flashed on your screen. Now, I would like to go to the very pleasant task of giving vote of thanks to our esteemed panelist, or rather esteemed panel. Friends, most of you would agree that Tiger Global's decision has led to opening of a Pandora box. Now, it wouldn't be out of space to state that Tiger has entered the conference room of multinational enterprises who have businesses in India. Today, we saw a brainstorming session wherein various nuances were discussed. Even practical implications arising from this judgment were discussed. We witnessed a detailed discussion on various facets, such as how will GAR and JAR will operate, issuance, what would be the impact on Form 15CB in light of this decision, what will happen to the past litigations and on the ongoing decisions. Sayal sir, Rajan sir, and Rajesh sir, everyone have gave that really insightful thoughts on each and every aspects of various nuances. Mahesh raised very peculiar questions, which most of us could correlate. So I would really like to thank on behalf of BCS and the participant to Sayal sir, Rajesh sir, Rajan sir, and not to forget Mahesh also for this wonderful panel discussion today. It was really very enriching for all of us. Thank you, everyone.